Before you assume a copyright registration guarantees a win in court, you need to hear this.
I already own The Matrix and Terminator from the beginning because my book and script was adapted into those derivative films that everybody loves and see on TVs. It's just like I'm the mother and I have 2 or 3 kids. They're derivatives of the source. I'm the source. So the book and the script are the source, and the movies, they're nothing but, derivatives.
Okay. The ownership attorney enters the chat. So Sophia Stewart alleged that 20th Century Fox, along with the writers of Terminators 1 through 3, and Warner Brothers, along with the writers of The Matrix 1 through 3, infringed on her copyrighted work by making a derivative of the third eye. According to the records, her treatment was federally registered in 1983. The full manuscript was registered in 1984. She contends she mailed the treatment to the VP of Creative Affairs at Fox and then later mailed the full manuscript to another employee of Fox after they requested it. Fox did acknowledge receiving the materials, but they stated that it was not involved in creating or producing any Terminator and that it did not have a relationship with the creators until after the first film was released. So the creators didn't have access to what she sent them. That matters legally because access must be tied to the people who actually created the infringing work. As for The Matrix, which was released in 1999, Stewart alleged that she sent her manuscript in response to a national magazine advertisement in 1986 solicited by the Wachowski brothers. They denied ever placing such an advertisement. She could not present evidence of that advertisement or her response to it. I reviewed the case, and here is the main reason she did not prevail. And despite internet rumors or interviews, she never received a money judgment for these claims. To prove copyright infringement, you must meet 2 elements. Element 1, ownership of a valid copyright. She proved this element because her federal registration established a valid claim of ownership. It then shifted to the other side to disprove it. So make sure you federally protect your work before infringement to establish a valid claim. But element 2, proof of copying, the protected elements. When there is no direct evidence of copying, the law requires proof of access to the copyrighted work by the infringer and substantial similarity between the works regarding the protected expressions. If access cannot be proven, the works must be strikingly similar, which is a higher, much higher standard than substantial similarity. She could not provide direct evidence of copying or a reasonable possibility of access by the creators of the work. And because they denied having access, she lost. To protect and defend your content, control how you share your work, because if you cannot later prove who had access, what they received, how they got it, when they had it, it will be hard to satisfy the second element and will require you to have to prove a higher standard. If you share your work, keep a documented paper trail, use NDA language, send it only to identifiable, accountable recipients. Include legal counsel in the communication, especially if you're going to send a full manuscript. Avoid responding to broad public solicitation. Access must be provable, not by bare possibility, but reasonable possibility. This is why I'm the ownership attorney.